Hello friends, this is Sanjay Arora from New Delhi, India. I welcome all of you to my YouTube channel Legally Determined, and today's thrust is on how to draft a deed without meeting a lawyer. First, we have to understand the definitions of document, conveyance, instrument, deed, document. In general parlance, anything written on is a document. But in legal parlance, a document is a writing which creates rights, duties, or obligations between parties. The Section 3 of the Indian Evidence Act 1872 defines a document to mean any matter expressed or described upon any substance by means of letters, figures, or marks, or by more than one of those means intended to be used or which may be used for the purpose of recording that matter. The Section 3, subsection 18 of the General Clauses Act 1897 also defines document in the same words, with the difference that while the definition in the Indian Evidence Act is exhaustive and in the General Clauses Act it is inclusive. The Section 29 of the Indian Penal Code 1860 is the same as in the Indian Evidence Act, except that for the last words, for the purpose of recording that matter, the words are as evidence of that matter. The definition involves a piece of paper on which something is written by hand or typed or printed. Conveyancing. The law and practice of effecting property transaction and of contracts in general is commonly known as conveyancing. The conveyancing means an instrument or deed through which one or more living persons transfer his or their interest in present or in future in or upon an immovable property to one or more living persons known as the transfer inter vivos. Movable property can be physically given and taken by actual delivery. While this is not possible in case of immovable property, the transfer of immovable property is not otherwise possible than by conveyancing. Instrument. The Indian Stamp Act 1899 defines an instrument to include every document by which any right or liability is or purports to be created, transferred, limited, extended, extinguished, or recorded. Deed. In a broad sense, deed means something done or performed which is synonymous with act. In legal sense, deed means a solemn act denoting document. It is called a deed because it is considered the most solemn and authentic act that a person can possibly perform in relation to his property. Second, difference between deed and agreement and contract. The Indian Contract Act 1872 provides for agreements and contracts. In a contract, there must be offer and acceptance, an intention to be legally bound, and consideration, namely, the parties have reached a bargain, and consideration shows that the parties have bought the promise by doing some act or providing something in return in value for the promise. Consideration entails quid pro quo. In a deed, there is no requirement for consideration to pass for a deed to be legally binding. For instance, gift deed, there is no consideration in gift deed, financial guarantee or letter of credit and indemnity deed. The Section 4, subsection 1 of the Sale of Goods Act provides if the property in the goods is transferred instantaneously, this is a contract. The Supreme Court of India in Hyderabad Engineering Industries versus State of Andhra Pradesh 2011, Volume 4, Supreme Court Cases, page number 705, has laid down that if the transfer is in present, it is called a sale. But if the transfer is to take place at a future time and subject to some conditions to be fulfilled subsequently, this is called an agreement to sell. The limitation period under Article 65 of the Limitation Act 1963 For initiation of the suit in court for possession of a movable property or any interest therein based on title is 12 years, while the limitation period under Article 14 of the Limitation Act 1963 for initiation of the suit in court for the price of goods sold and delivered where no fixed price, where no fixed period of credit is agreed upon is 3 years. Third, classification of deeds in England. Deeds can be classified in England into two categories. First, deeds poll and second, indentures. Historically in England, deeds were classified into deed poll and indenture deed. Deeds poll. Deeds poll are those in which there is one party only and are so called because they were at one time polled or cut level at the top. They are mainly used for granting powers of attorney and for exercising powers of appointment or setting out an arbitrator's award. They are drawn in first person. Deeds poll generally commence with "Know all men by these presents." If there are no recitals, recitals are explained below. Then with "To all whom these presents shall come greeting." Indentures. A deed is technically called an indenture or deed indented because the old practice in England was to cut or indent for the purpose of a tally. The old practice was to write two copies of the deed upon the same piece of parchment or substance, with some words or terms or letters of alphabet were so written that when one copy was separated from the other, the substance or parchment was so cut or indented so as to leave half of the word or letter in one copy and the other half in another copy so as to fit or aptly join its counterpart from which it was supposed to have been cut, indented, or separated. Types of deed. Deeds may be divided into three parts. First, deeds regarding transactions of immovable properties. Second, deeds regarding transactions of movable property. Third, deeds regarding business or commercial transactions. Deeds regarding transaction of immovable property. The list is not exhaustive and the list does not include agreements for sales, etc. Deed of conveyancing or sale. Deed of mortgage or submortgage. Deed of transfer of mortgage. Deed of lease. Deed of sublease. Deed of assignment of lease or sublease. Deed of surrender of lease or sublease. Deed of exchange. Deed of gift, deed of trust, deed of partition, deed of release or relinquishment, leave and license. Second, deeds regarding transactions of movable property. The following list is not exhaustive. Deed of hire or hire purchase agreement. Deed of trust of money or movables. Deed of hypothecation or pledge. Deed of assignment of business and actionable claim. Third, deeds regarding business or commercial transactions. Deed of partnership, dissolution or retirement. Indemnity bond, surety or guarantee bond. Third, power of attorney. Components or division of the deed. First, the name or description of the deed. A deed starts with the name. For instance, in the case of a sale, this deed of conveyance or sale. In case of a mortgage, this deed of mortgage. It is desirable to give the name of the document, but it is the contents which decide the name and nature of the document. Second, the date and place. It is a common practice to put the date of the document and place of execution thereof in the beginning of the document. It is really made when a document is delivered. The date can be put in the testimonium clause explained below or below the signatures of the executing parties too. In a deed of indenture, the deed is given first. In a deed of indenture, the date is given first, while in a deed poll it is given at the end. Putting the date at the beginning, it is the best way so that one does not have to hunt for the date. For instance, this deed is made at dash 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 the dash 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 day of dash 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 in the year. The date is of great importance in case of limitation and registration. The date is strictly speaking not an essential part of the deed. The deed is perfectly valid if it is undated or the date given is an impossible one, namely, for instance, the 30th day of February. Section 47 of the Registration Act provides that the document, when registered, takes effect from the date of execution and not from the date of registration. If no date is given to prove the execution, oral evidence will always be admissible. Section 23 of the Indian Registration Act 1908 prescribes the period of 4 months within which a deed is presented for registration. If several parties to a deed sign it on different dates, the last of such dates is regarded as the date of the deed. This place assumes importance in matters of collateral purpose or jurisdictional purpose of any court of law. Next, parties to the deed. Every document has minimum two or two sets of parties, namely a transferor or transferors and transferee or transferees, except a deed poll as a power of attorney or a will. To avoid the repetition of the name of the parties, we describe the parties by a common or single word and expression given the nature of the document. For instance, in the case of a gift as donor and donee, in the case of a trust as settler and trustee, in the case of mortgage as mortgager and mortgagee, in the absence of any suitable expression, the parties can be described as party of the first part, party of the second part, etc. A document transferring property is not only binding on the parties but also to the parties claiming through them, such as legal representatives or successors or assigns or heirs or executors or administrators in the case of an individuals, and in the case of corporate bodies, their successors and assigns. Under the Old English law, to pass an absolute estate to the transferee, the expression used was to A and his heirs, or to A in fee simple. If the property was conveyed only to A, it was construed as a transfer for A's life only. In a conveyance here means the transfer of land or the deed which transfers. Words which have the effect of making the duration of an estate are termed words of limitation. Thus, in a grant to A and his heirs, the words his heirs are words of limitation. The term grant means the creation or transfer of ownership of property by a written instrument. Next, recitals. Recitals in a document are synonymous to the preamble of a statute. Recitals state the preliminary ground for the execution of the document. They constitute a brief history of the facts and events leading to the execution of the document. Recitals are of two types: narrative recitals and introductory recitals. Narrative recitals are generally not required in an ordinary contract. Narrative recitals trace the title of the transferor to establish prima facie his right or title to execute the document. Narrative recitals are imperative if there are any interim events or facts between the root of title and the acquisition of the rights of ownership by the transferor to transfer the property or his interest therein. Because of a previous deed of absolute transfer, the transferor has become the full owner of the property. The document is the root of the title. The word whereas should be used in the beginning of the recitals and the recitals should be numbered in figures or letters. For instance, whereas the transferor is absolutely seized and possessed of or otherwise well and sufficiently entitled to the property. Whereas the transferor is the full owner of the property, it can also be drafted as well. This is the well established principle of the English jurisprudence that the title of the man seized of the land prevails against all who can show no better title than seizin. Seizin means possession. Seizin is the root of the title. The same is the case in India. If the transferor is not the full owner, his root of title commencing from the title of the previous owner or purchaser of the property under the last document of transfer till the acquisition of the right of ownership by the transferor under a will or trust should be stated. The other type of narrative recitals traces the events subsequent to the transferor acquiring the title or ownership to the property. For instance, when the transferor has created a mortgage or lease on the property and the property is to be transferred subject to mortgage or lease. If it subsists, it should be recited. If the deed of transfer is executed under any power conferred by the previous deed or by power of attorney or by court's order, the document conferring such power should be recited. Introductory recitals. Introductory recitals state the motive or object of executing the deed of transfer. If the property is to be sold or mortgaged, the agreement to sell or mortgage with the purchaser or mortgage should be recited. If there is special terms of the agreement requires the transferor to do any act, such as obtaining any permission from any person or authority to transfer the property for making the title marketable and the payment under such agreement should be recited. Verbatim annotations from the previous date should be given only when they are absolutely necessary. Otherwise, the provisions therein should be summed up. The written agreement for sale should not be recited in the deed. Instead, it should be recited that whereas the vendor has agreed to sell to the purchaser and the purchaser has agreed to purchase the land. The agreement for sale in writing should be recited if certain events have happened to change the nature or terms of the agreement. The facts should be recited in the chronological order. Only those contents of the document should be recited which have relevance to the operative part explained below. In case of the assignment of lease, the lease should be recited, but the means intervening assignment need not be recited. Only the last assignment of lease be recited. If the transferor is the absolute or full owner of the property, his previous title need not be recited. But if he holds a limited interest, namely if he is a mortgagee or a leasee or a trustee, or if his right to transfer is derived by inheritance or under a will or under or a court's order, the recitals should commence from the last full owner of the property. The recital should make the title self-contained. Fifth, testatum. Recitals are followed by the provisions relating to the main document of transfer. The main document begins by the standard expression known as testatum. Now, this deed witnessed that in pursuance of the premises or pursuant to the said agreement and in consideration, the expression premises in the phrase in pursuance of the premises means the four parts of the deed before the habendum explained below, namely what has gone before. In case of an agreement where there is no transfer of property or the transfer of movable property is involved, like a deed of pledge or deed of hypothecation, the expression used is now it is agreed and declared by and between the parties as follows. The testatum refers to the introductory recitals of the deed, if any, states the consideration, if any, and recites the acknowledgement of its receipt. The testatum clause is ultimately linked with the testimonium clause explained below. Next, consideration. It is necessary to state the consideration in every document, whether it is paid or agreed to be paid or partly unpaid. Although the non-payment may not vitiate the document which is duly executed, registered, or and acted upon. The document may be void if there is no consideration at all. Section 53, subsection 2 of the Transfer Property Act provides that every transfer of movable property made without consideration with the intent to defraud a subsequent transferee shall be voidable at the option of such transferee, but no presumption of fraud arises from mere inadequacy of consideration. Seventh, receipt clause. The consideration clause also contains a receipt clause. This is a standard practice, though it is not absolutely necessary. It is also the practice to incorporate a separate receipt clause at the end of the document. The receipt clause uses the words admit and acknowledge. Eighth, operative part. This is the real operative part which follows the consideration clause. The operative part is usually worded as follows. The vendor doth hereby grant, convey, etc. unto the purchaser. The operative part refers to the nature of transfer intended to be made. For instance, in the case of lease, the words used are demise or grant by way of lease. The Transfer Property Act 1882 uses the word convey in Section 5 and Section 55 Roman 1 and English alphabet D. In section 5 of the SAD Act, it is used in general sense of transfer and not in the restricted sense of sale. In section 55, 1D, the word convey indicates sale. In general practice also, the word convey has acquired the meaning of sale. A deed of conveyance generally means a deed of sale. In ordinary contracts or agreement, there are no operative clauses as such as no transfer property is involved. Ninth, parcel. The word parcel in Latin parcella was originally applied in the sense of a piece of land only. In modern usage, the description of property intended to be transferred is called parcel. The full description of the property is given in the body of the document itself after the operative part or is given at the end of the document, but before the testimonium clause or immediately thereafter and not by annexing it separately. The usual phraseology used is as follows: all that piece of parcel of the land or ground with the mass wages here Hiri determines and premises situated at dash 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 and more particularly described in the schedule hereunder written. Mass wages mean a dwelling house with outbuilding and land assigned to its use. It is not desirable to give the full description of the property in the body of the document. Mention only the situation of property. B. The identifying revenue or municipal number of such property, namely survey number, city survey number, house number, etc. C. A reference to the schedule containing the full description of the property. D. The plan of the land if the plan is proposed to be attached. The phraseology should be as follows: all that piece of land or parcel of land situate at dash 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 bearing survey number dash 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 or CTS number dash 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 and more particularly described in the schedule hereunder written and delineated on the plan here to annexed by boundary line colored red or as the case may be. CTS number, city title survey number is for property owners, buyers and sellers in Mumbai, necessary for a property during the property registration process and during the payment of stamp duty. Section 21 of the Indian Registration Act 1908 lays down that no non-testamentary document relating to immovable property can be accepted for registration unless it contains a description of such property sufficient to identify of the same. Section 21 further provides that houses which are situated in towns should be described as situated on the north or other side of the street or road to which they front by their existing and former occupancies as also by their numbers if such houses are numbered. Other houses and lands should be described by their names, if any, specifying the territorial division in which they are situated, and also by their superficial contents, the roads and other properties on which they abut, and their existing occupancies, and also wherever it is practicable by a reference to a government map or survey. Further, if a non-testamentary document contains a map or plan of any property, it cannot be registered unless it is accompanied by a true copy of the map or plan as the case may be. 10th, all estate clause. This clause follows the parcel. This clause is not found in a deed of lease, deed of appointment, or a deed of trust, etc., or in ordinary contract or agreement. All estate clause is so called because it purports to convey all the estate right, title, interest, claim, and demand of all the conveying parties in the premises. This clause is incorporated in those instruments of alienation where the entire interest of the conveying parties is transferred. The usual wording of the clause is together with all and singular. The houses, buildings or building courts, yards, areas and plants, shrubs, ways, paths, passages, common, galleries, walls, water courses, lights, liberties, privileges, easements, profits, advantages, rights, members, and appurtenances whatsoever to the said land and premises or any part thereof, now or at any time hereto book for usually held, used, occupied, or enjoyed, and reputed or known as part, member thereof, or to belong, or to be appertinent thereto, and all the estate, rights, title and trust, claim and demand, whatsoever at law and in equity of the vendor into, out of, or upon the said land and the premises or any part thereof. This clause may be abridged as follows: together with all the house and structures of whatsoever nature standing thereon, the areas appertaining thereto, and all the privileges, rights, advantages, and things whatsoever attached to the said land and premises or any part thereto belonging or anywise appertaining thereto, and usually held or enjoyed or reputed as part thereof, and all the state right, title, and interest, claim, and demand whatsoever of the vendor to or in relation to the said land and other the premises or any part thereof. Section 8 of the Transfer Property Act 1882 deals with the effects of a transfer. It lays down that unless a different intention is expressed or necessarily implied, a transfer of property passes forthwith to the transferee all the interest which the transferee is then capable of passing in the property and in the legal incidents thereof, namely, where property is transferred is a house, the legal incidents of the property which pass to the transferee are the easement annexed thereto. Second, the rents thereof accruing after the transfer. Third, the locks, keys, bars, doors, windows, and all other things provided for permanent use therewith. Section 8 of the Transfer Property Act embodies the legal maxim accessory follows the principle. 11th, Havendum. All parts of a deed before the Havendum are called the premises. Premises, premises or premise means, and as explained earlier, all parts of a deed before the Havendum are called the premises. Premises or premise means, as explained earlier, what is stated before. The office of the premises of a deed is twofold. First, to name the transferor and the transferee. Second, to comprehend the certainty of the lands and tenements. A havendum has two parts. First, to name the transferee. Second, to limit the interest of the estate. The office of the havendum is to define or limit the duration of the estate to be taken by the guarantee, so that the general implication of the estate, which by the construction of the law passes in such premises, is by the havendum controlled and qualified. The expression unto and to the use of has the reference to which both legal and beneficial interest in the property, namely the whole interest in the property intended to be transferred, is transferred. The above expression is used in a sale, mortgage, or lease. In the case of a trust, the expression would be to have and to hold the land and premises unto the trustees, but upon the user as follows. In the case of a lease, the addendum is also called redundum. If an express estate be limited with the premises and an estate be created in the addendum in consistent with the estate limited in the premises. Addendum is also called addendum if an express estate be limited with the premises and an estate be created in the addendum inconsistent with the estate limited in the premises. In such case, the premises shall be good and the addendum void. 12th, exceptions and reservations. Preceding the addendum clause and following the all state clause, a clause by way of exception or reservation is sometimes added. An exception is something in existence at the date of transfer, which is not expressly accepted, would pass the property as described in the parcel, such as trees. A reservation is something not in existence at the date of the transfer but is newly created by the grant, namely what the vendor reserved a right of way over the property. 13th, terms and conditions. After the addendum clause come the terms and conditions subject to which the property is transferred. The usual clause is regarding the conditions for payment of future liabilities in respect of the property by way of taxes, etc. The usual wording of the clause is subject to payment of all rents, rates, assessments, taxes, and duties now chargeable, or hereafter to become payable upon the same to the municipal corporation or to the government or any other public body or local authority in respect thereof. If the property is transferred subject to the existing mortgage or subject to the claim of any person for maintenance, easement, or otherwise, the property will be conveyed subject to such mortgage, claim, easement, or otherwise. 14th Covenants. Covenants is agreement by deed. With covenant, the words agree or promise are not used. Covenants are collectively and in usual parlance are called covenants of title. Though all of them are not covenants of title, in the case of transfer by way of sale or mortgage, there are usually four covenants. First covenant for title, second covenant against encumbrances, third covenants for peaceful possession, fourth covenant for further assurances. These covenants are express covenants and can be specifically enforced. The Transfer of Property Act refers to only one covenant out of the four covenants mentioned above under Section 55, subsection 2. These four covenants are generally provided in a deed of sale of freehold and leasehold and in a deed of mortgage. The deed of lease, the deed of trust, or the gift deed does not use these four covenants. The purchaser normally does not give any covenant in a deed of conveyance, also known as deed of sale. However, in certain circumstances, the purchaser also has to give covenants. For instance, if the purchaser has not paid the full price and the balance is to be paid in future, the purchaser shall give a covenant to pay the balance as stipulated under Section 108 of the Transfer Property Act. The leaser gives an implied covenant for peaceful possession or quiet enjoyment. This is an unqualified and absolute covenant. There is no consideration in case of trust and gift. These covenants are not included in these dates because these are voluntary transfers and the question of the transfer guaranteeing the title does not arise. Covenants are of two types: covenants running with the land and personal covenant. Covenants running with the land are those when the benefit of the land in law or in equity passes to the successors in title of the covenanter or the covenantee, as the case may be. Covenants running with the land are attached to the property and not only the covenantee, but his heirs and other legal representatives, successors, assigns would be entitled to the benefit of such covenants against the covenanter, his heirs and legal representatives. Covenant running with the land is a restrictive covenant because it imposes restriction on the use of land, namely covenants giving a right of way. 15th Testimonium. After the four covenants, the deed of conveyance ends with the Testimonium clause. If there are special provisions to be included, they shall come after the covenant. The additional provisions may be a covenant to produce document. Special terms and conditions can also appear after the covenant. Testimonium clause runs like this: in witness whereof the vendor has put his hand or signature, or the vendors have put their respective hands or signatures on the day and year first hereinabove written. If the date is not mentioned in the beginning, the wording would be as follows: this dash 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 day of dash 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 in the year. In the testimonial clause, the word hand and seal are usually mentioned. 16. Schedule of property. After the testimonial clause, the schedule containing the full description of the property comes. The description shall contain the area of land in square meters, survey number, the buildings and structures with their municipal numbers, boundaries. 17. Signature clause or execution. There is a difference between execution and signing a document. Execution of a document consists in signing a document written out, read over, and understood, and does not merely mean signing a blank paper. In the case of a deed of conveyance and a deed of mortgage, it is executed by the vendor and the mortgager. The practice is to put the signature against the bracketed position containing the following clause in case of individuals: signed and delivered by the within named vendors or mortgagors XYZ in the presence of. 18th. Electronic signatures and authentication. The definition of digital signature is given under Section 2, uh, Clause B of the Information Technology Act 2000. The word subscriber in the SAD Act means a person in whose name the digital signature certificate is issued. The Information Technology Act 2000 does not apply to a negotiable instrument as defined in Section 13 of the Negotiable Instrument Act 1881. A power of attorney as defined in Section 1A of the Power of Attorney Act 1882. If a trust as defined in Section 3 of the Indian Trust Act 1882. Fourth, a will as defined in Clause B of Section 2 of the Indian Succession Act 1925 or any other testamentary document. Fifth, a contract of sale or conveyance of immovable property or any interest therein. 19th, attestation. Every document relating to immovable property or otherwise is not required to be attested by one or more witnesses. There are only three documents required to be attested by at least two witnesses: the deed of mortgage under Section 59 of the Transfer Property Act 1882. Second, the deed of gift under Section 123 of the Transfer Property Act. Third, will or codicil under Section 63 of the Indian Succession Act 1925. The mortgage of ship is to be attested by two witnesses under the Merchant Shipping Act 1958. Documents affecting sales, exchanges, and leases need not be attested. The definition of attested is given under Section 3 of the Transfer Property Act, which means that a person has signed the document by way of testimony of the fact that he saw it executed. For a valid attestation, there must always be two or more attesting witnesses, and it is necessary that each witness must see the executant sign or affix his mark to the instrument or see some other person sign the instrument in the presence and by the direction of the executant. It is essential that the witnesses should have put their signatures animus attestandi, namely for the purpose of attestation. If a witness puts his signature as identifier, he would not be an attesting witness. 20th, sealed and delivered. A deed is different from contract. On a contract for sale of land, the contract is not binding on the parties until they have exchanged their parts, but a deed is binding on the maker of it, even though the parts have not been exchanged, so long as it has been signed, sealed, and delivered. Delivery in this context does not mean handed over to the other side. Delivery means an act done so as to evince an intention to be bound, even though the deed remains in the possession of the maker or his solicitor. He is bound by it if he has done some act evincing an intention to be bound by saying, I delivered this by act and date. However, he may make the delivery condition, in which case the date is called an escrow, which becomes binding when the condition is fulfilled. 21st, receipt clause. Receipt clause happens in the case of a deed of conveyance, mortgage, or lease, or any other document where some money consideration passes. The receipt clause is not absolutely necessary if the receipt for consideration admitted or acknowledged in the body of the document after the testatum clause, but it is the practice to add this clause or provision for better caution. The receipt clause runs as follows: received the day and year first herein above written of and from the within named purchaser or mortgagee or lessee a sum of rupees dash dash dash, which together with the amount of rupees dash 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 paid earlier and earnest or otherwise makes up a total amount of rupees dash dash dash, being the full consideration to be paid by purchaser, mortgagee or lessee to me or us witnesses, I say received. Last, 22nd, stamp and registration. Every document except a will is required to be stamped under the Indian Stamp Act 1899 and registered under the Indian Registration Act 1908. Stamping the document is the first step. First, stamping the document is the first step, and registration is the last step. A document is required to be stamped before or at the time of execution or immediately thereafter. Under Section 17 of the Indian Stamp Act 1899. The Indian Stamp Act is an all India act, but the stamp duty is a concurrent subject under the Constitution. Registration is done after the document is fully and properly executed by the parties. Registration is compulsory under Section 17(1) of the Indian Registration Act 1908. Every document which creates or declares or releases any interest in an immovable property worth more than rupees 100 requires compulsory registration. A document which requires registration but is not registered is not void, but it is not admissible in evidence as provided in Section 49 of the Reservation Act. So we have discussed how to draft a deed without meeting a lawyer. This is one of the comprehensive details I have given to you, and many thanks to you for watching this video. And I would like to thank Mr. Ankush. Without his help, this video could not have seen the daylight. Many thanks to you. Please do like, share, and comment on my channel. Many thanks to you. Break a leg. Thank you.